Welcome to the fourth day of ADR week and the first session for today. All the panelists have joined us and we are now ready to start. My name is Juhi Gupta. I'm a principal associate with the dispute resolution team at Shardul Amritchan Mangaldas and Co. Today, I have the pleasure of introducing our vastly experienced and diverse panel that will be discussing a very interesting topic, which is the what, why, how, and when of maintaining records for an arbitration, the whole 9 yards. This session is sponsored by Khaitan and Co. And we have a very distinguished panel to discuss this important and interesting topic. To start with the introductions, we have with us Mr. Chakrapani Mishra, partner dispute resolution at Khaitan and Co. Mumbai. He has more than 2.5 decades of experience in commercial dispute resolution and has been regularly ranked as a leading lawyer in the field of disputes resolution. We also have Mr. Raj Panchmatia, again a partner in the disputes resolution team at Khaitan and Co., who is also moderating the session. Mr. Panchmatia handles matters in both domestic and international fora. He's also been appointed on the SIAC panel of arbitrators and is on the HKIAC list of arbitrators. He's also on the panel of SIMC, is an India specialist mediator and a Singapore International Mediation Institute accredited mediator. We then have Mr. Rajendra Mishra, General Counsel at Indian Hotels Company Limited. He has more than 24 years of experience in the legal field and extensive experience in various fields, including IPR, competition law, litigation management, corporate law, among many others. He has previously served as the in-house legal counsel of several leading corporations, including Hindustan Unilever Limited and ITC Limited. We have Ms. Smitha Menon, partner at Wong Partnership. She heads the firm's restructuring and insolvency practice and is a partner in the International Arbitration, India, and Special Situations Advisory Practices. Ms. Menon is on the Shanghai Arbitration Commission's panel of arbitrators, ICC Commission on Arbitration and ADR, and the Board of Singapore, and is a fellow of Insolvency Practitioners Association of Singapore. We have Mr. Vineet, GC Tech Mahindra, who has over 25 years of experience in legal, secretarial, regulatory, risk and compliance, corporate and public affairs in leading IT, engineering, banking, and non-banking financial companies. He has served recently as the Senior Vice President, Legal, Commercial, Regulatory, Compliance, and Public Affairs at HCL Technologies Limited for over 11 years. So we have an extremely stellar panel, and with these introductions, I will hand over to Mr. Panchmatia to make his introductory remarks and proceed with the session. Thank you.
Thank you, Juhi, for the kind introduction. Thank you, MCIA, for organizing this. Thank you to all panelists for taking out time for doing this session early in the morning. Thank you all the guests and everybody in the audience for joining us. As you know, arbitration itself is quite daunting, and to maintain records is extremely important. And if you don't have records in place for arbitration, you know the kind of complications it can create during the arbitration in the evidence, and which eventually impact the results of arbitration. So it's extremely important that we maintain contemporaneous records prior to the arbitration, just before when the disputes have started to brew between the parties, or even prior, even at the stage when the documentations were being entered into, the negotiations that were being conducted. It's very important that parties maintain that record. And it cannot be stressed how important this issue is. And very often it's overlooked. Therefore, today we'll explore in brief what, why, how, and when of maintaining records for arbitration, and will hopefully provide some practical guidance and practical tips from some of the best GCs that we have around, the international lawyers, and my partner, Chakrapani Mishra. Without taking way too much of a time on introduction, I'm going to start with my first question to Mr. Mishra. And that's going to be, Chakrapani, as a lawyer, when somebody comes to you and you are strategizing and you're helping them strategize the disputes, while strategizing to invoke an arbitration, what documents, records are considered most relevant?
Right. Thank you, Raj. And good morning, everyone. And it's absolute pleasure and it's my good fortune to be on this panel with very distinguished colleagues. And good morning to everyone who has joined. Thank you. Coming to the question, we do face this difficulty when we start strategizing for a matter, namely that the client comes and says that, look, there is this dispute, story is told, notes are taken. But when it comes to actual documentation, the standard response that comes is, no worries, we will provide it to you, please go ahead. And that's where the actual challenge begins. And then we begin to talk about it, okay, maybe put in a list for you, and then actually the list follows. And I'm going to share that list with you because I think the practical experience will help better than just theorizing it. So the primary list that we provide and we expect a client to have before a matter is conceptualized and put before the tribunal is the chain of documents, the first set of contracts that you had in a transaction, or the first set of documents that established a relationship which is going under dispute. So those are your primary documents. You start with your contract, you start with any amendments to that, you start with any modification done post that which are agreed upon by the parties. Those are your primary documents which you need to have. The secondary to that would be, the corollary would be to have all the documents which are related to the transaction, which may be your set of letters, which may be minutes of the meetings, which may be notes taken and agreed upon by the parties. And those are the secondary documents which come back to support the main dispute. Now, why are documents important? Because if we look from arbitrator's perspective, ultimately an arbitrator is going to get to the facts on the basis primarily of documents, and then of course secondary evidence and witness statements, etc. can come. So the most important, the most key thing here is maintaining the documents. Now, what happens if we don't have those documents in place? Problem arises because your very foundation may go wrong. You may end up presenting a case which is not sustainable. While that is before filing your case. Once you have filed the case, then the problem arises that if you are going to be examined on evidence, again, it may not be substantiated. Similarly, if you are going to confront a witness with a document which is incomplete or which is not properly recorded, it may lead to very disastrous consequences. So the answer to your question as to what documents are required is, in a short word, everything related to the transaction. If I have to attempt a list, it will be what I said earlier, the chain of agreements, amendments, letters, memorandums and minutes of the meetings, and any correspondence related to the transaction, your electronic records, as well as any videograph records which are legitimately obtained and which are not tampered with. So this is in a nutshell what we need in order to have a successful dispute. Thanks.
Thank you. Thank you, Chakrapani. I think this is a very helpful what you said, because it sets the context for our next question, and it also sets the context for our entire webinar, because what are the important documents that you need to maintain is very, very critical in any arbitration. Now, once you identified the documents, Vineet, as an organization, as a big organization like yours, what would you say are the best practices to maintain and store these records, documents and records? Both, I would say both in physical form and in electronic form, because in today's day and age, things are moving to electronic records. So what would be the best practices to store this documentation either in physical or in electronic form? Your thoughts?
So good morning, and it's a pleasure to be here, and thank you for having us all and put us all together. So thank you so much, Raj. And I'm going to pick up from where Chakrapani just left. He says, they draw out a list. I mean, as an external firm, when we go to a list is drawn out, sent to the client, and there is where our worry starts. how do we kind of satisfy with all the documents that are being sought for? Because in our understanding and having worked closely with business, we feel these 4 or 5 documents are good enough to win us the case, be it in litigation or be it in arbitration. So we kind of, the first reaction is to say, do we really need all of this? But yes, that's the lighter side of it. But going back to the, the serious part is the fact that, and rather, let me just step back on how we've kind of moved between physical and electronic, and then kind of I can come back on, the best practices, etc. So to me, I think the contracts are getting written online. We moved to that system now, and especially post-COVID, 100%, but even pre-COVID and with the digitization push at the government level, etc. So I think we are into a phase that we are talking of electronic e-contracts, smart contracts. We've not reached really, but I think we are all in the journey. And I think this COVID, as we said, has expedited the whole story. I mean, as a small example, we are creating contracts on a daily basis. We want the Blinkits and the big baskets to deliver in, say, 15 minutes. And then we want the dispute or the issues that arise also to be kind of resolved in the next, 15 minutes and so on. So I think, and which is really getting facilitated through, I would say, IT technologies, digitization, and so on and so forth. So that being the background, I think it's important that, be somebody who wants to litigate tomorrow, or, who could be an aggrieved party, but maintenance of records for all purposes is prime. We've had a good system, or I think the corporations built a great system around physical record keeping. There were times that, you would put, for example, I mean, just as an example, if you were bidding for say a tender or a government project, so it would all start with, the initial meetings that would happen, the minutes of the meetings, to RFPs, the bids submitted, to, corrigendums issued, to clarifications got. So all that we put together. I mean, that happened in the physical phase, so as to call it simply. But having moved to the electronic phase, where we are now talking of, everything being digitized, and correctly so, because, there are environmental issues around paper and many other aspects also. And then you have the ease of doing it very fast, quickly, and, reaching to the point that you want to very quickly. So electronic has its own advantages. So therefore, we moved to a system of electronic maintenance of records. So I think, and then you also have the SEBIs and the Companies Act and, Ministry of Finance, etc., having those framework also to support, and the IT Act, of course. So as an organization, what we really do is to a fact that, as an example, when I conceive a contract, or even the discussion was to start in, we put, or we create files, we give them unique numbers. And there is a parallel to this also, which I will come subsequently, but an ID gets created. And from that ID perspective starts the whole journey of the transaction. And, the teams come in, the emails get mapped, and all of that gets to be put together. And then it follows with the contracting phase, where, the contract, and coincidentally, we've moved to a system where we don't do any manual contracting as an organization. So what we really do is, our contracting also happens, online. So I would redline, there will be versions control, etc. And the same version, etc., would go to the customer and come back, and so on and so forth. So there is a whole singular place, or a common place where all the records are getting stored. The problem, however, comes is the fact that, there will be post award of the contract, when it gets into communications, variation of contracts, so as to say, by communications and by, certain actions taken expressly, impliedly, etc. So that's a piece which gets kind of missed. And I think that's very important from an arbitration standpoint also. I think what we've done is we've created a system of, one, putting it into a common place as an organization. The informations are encrypted, the mailboxes are protected, backup taken, and, for all the big projects, we kind of create files with IDs. So I think we try to put it at a common place, all of it together, and keep it all there. So and fortunately, whether you do a contract in online form or these, click wraps and so on and so forth, all of that anyways is available, electronically. So it's how you put them together and how you then maintain the, what do I say, the integrity in the sense that it's not tampered with or it's not lost through corruption and, technological changes, etc. So I think there is this whole effort which goes into it. I think I can go on and maybe talk a lot about technology also, but I think that broadly is what we do. And then from a best practice perspective, very quickly, I think it's about, I would say, firstly, security and reliability. I think that's very important. So how do we get these records which are created are put into a place where they're secure and reliably, put together? I think how do we structure, index, and categorize, to me, is another pillar. And I think the best practices from a domestic and international standpoint can be relevant. So I think how do we see that this records is just like the physical part of it is properly structured, it's indexed and categorized for easy, getting to it and then maybe kind of retrieving it. We also have this system about information asset registrar so that you can use it from maybe a risk analysis and other perspectives also. But I think a review and audit is something that is part and parcel. And the last, or maybe the penultimate, would be retention policies and retention timeframes. I think we have these frameworks and legislations and guidelines. I think we'll have more detailed people to talk on it. But then I think it's all about that, and how do we kind of ensure that there is no alteration, export of this data, and the data itself or the records are not compromised. So a best practice around that in terms of our learning, etc., are a couple of things that we also practice from a standpoint of the best practices or the key pillars in terms of record creation and record maintenance for a eventual arbitration or a litigation, if God forbid it was to happen. So that's my.
Thank you, Vineet. I think this was very helpful to see as an organization what efforts do you all take and what are the practices that you follow to store the records, maintain the records, because bigger organizations have a lot of attrition as well. And when they have attrition, you kind of tend to lose the documents when somebody leaves and you don't know what their mailbox contained. So it becomes very, very difficult. But if the way you mentioned that you have a centralized data collection process where you collect everyone's data in that sense related to a particular matter, which can help a big way to meet that challenges.
And maybe that's, sorry to interrupt, but I think we also, as a multi-jurisdiction organization, have our learnings from this e-discovery in the US. And I think we've taken those as best practices and we kind of put that all together. So just to kind of supplement.
No, that's very helpful. I think that's a great way to, it's always good to learn from best practices across the world and implement them in the organization, because that's something helps you to grow. Smitha, I think some of the very important points made by Chakrapani and Vineet on, what are the records, how important it is to store them, what are the best practices. Now, having said that, what is the ideal time frame for the parties for them to preserve information records? Like how long? What is the time frame before, during the documentation process, during the arbitration process, post arbitration? What is the time frame that you look at when you are looking at someone or advising someone that you must have the records?
So I'll give the most irritating answer that lawyers love to give, and that's it depends. So, I mean, the time frame is really informed by what is your document retention obligation, and this varies from jurisdiction to jurisdiction. I mean, as a starting point, there are discovery or document production obligations in arbitration. It will either be in the jurisdiction's main statute or it will be in the arbitration rules. And I think it's widely accepted, and certain courts, including the Singapore courts, have made it clear that an obligation to disclose extends to an obligation to retain. In other words, not destroying documents which might have a possibility of being disclosed. So I think that's really the source of the document retention obligation. So your time frame has to sort of be such that you comply with that obligation to disclose. And the most common rules that are used in arbitration would be the International Bar Association rules on taking evidence, so the IBA rules 2020, or the IBA rules on party representation, 2013. The latter really applies to lawyers and it's usually often overlooked. So I thought I would highlight that because one of the things that lawyers should take note of is guideline 12 under the IBA representation rules, which requires a party representative to inform the client of the need to preserve documents from deletion, which might otherwise be in accordance with the document retention policy. So something Vineet said earlier made me think of this because he said that, oh, we do have a carefully thought out document retention policy, and that actually suits the organization's commercial needs. But as a lawyer, you have an additional obligation, I mean, if the IBA rules apply for your arbitration, to ensure that where you know, the first thing you must do is ask your client, what is your document retention policy? If it's 2 years, 1 year, 4 years, 6 months, I mean, it varies from organization to organization. And if you know that that's inconsistent with what you need, if you're planning for an arbitration that's going to come to hearing in a year, 2 years down the road, you have an obligation pursuant to guideline 12 to advise your client of this. So that's something that's often overlooked. So I thought it'd be good to highlight that. Now, I mean, I think everyone knows why you must comply with your obligation, because if you don't, then your pleading can be struck out, adverse inferences can be drawn against you. So these are all the reasons why you need to have a good time frame. And to answer your question, sorry for the roundabout introduction to frame the point, but to answer your question, how far back do we go? I think a conservative measure would be following your statutory limitation period. In Singapore, it's fairly long. It's 6 years for breach of contract claims. I believe under the Indian Limitation Act, it's 3 years, but I'm sure Chakrapani would, and Raj can correct me if I'm wrong. So that would be a safe period of time if before an arbitration to think how long to keep your records. Another approach would be the duration of the commercial relationship. So for example, if you are an MNC or a large organization, you would have one sort of master agreement, and then you'll have in the course of the relationship, individual or minor contracts that execute each transaction or each sale. And you would want to cover the period of the master agreement or the master license, because then you can rely on things like cost of dealing later on in the arbitration to buttress your case. So all the things that's not captured by clear contractual documents, and you want to run all these collateral agreement type arguments, you would need things like, oh, look at their conduct. This is how they've been doing it all this while. So the duration of the overall project would be another measure. A third factor, and the last factor that I would add, which I have learned the hard way from clients' arbitrations over the years, is when your employees or key management people leave the organization, your client's organization, that is when you must sit down that individual. If he's the key person handling the commercial transaction, sit him down and obtain a very simple witness statement documenting the key aspects of how the transaction was handled, and giving an account of any hiccups that could have arisen that can later on arise in the arbitration. So for example, if it's construction of a building and there's going to be liquidated damages claims later on for delays or accidents or something that may have happened, slight breaches or warranties that you're not exactly complying with, you would want to get that statement from that person now before he leaves. Because once an employee is gone, they're under no obligation to give evidence for you. And getting a subpoena, I mean, it just makes it more hostile to the person giving evidence. So it's good to sit the employee down when they're leaving, make it all part of the amicable exit to, hi, could you just give us a witness statement? We'll put in a good word for you. You can use this as a reference for your next job, so on and so forth. The times are good. Extract as much information as you can. One of the things I saw, which turned out to be very useful, was an organization which was quite aggressive. They took the employee's WhatsApp chat history, because that employee was the key person dealing with his counterpart on the other side, the counterparty of the contract. And that WhatsApp chat history turned out to be so important because his counterpart had left the counterparty's organization. And so during the arbitration hearing, the only evidence for the other side actually came from our side. And so it was really good because you could control the narrative a lot more greatly. I'll stop there in case Chakrapani has anything he wants to add on how much earlier before the dispute to store documents.
Raj, with your permission.
Yeah, please go ahead.
So, Smitha, you make two very good points. One is that the internal policy of an organization may not be what is required for a dispute. And in India, it's 3 years, yes, But also one point to be borne in mind is that under income tax obligations, you are supposed to keep the documents for 7 years. So probably it would be good to take the outer limit rather than take the inner limit. So that was one. And also your second point, I cannot resist the temptation of commenting as to how useful this witness statement or a statement by an employee, key employee leaving the organization can be. It has been a lifesaver in many disputes. And as you rightly mentioned, there are situations where the key person on the other side is not there. So you have your whole construct and you can probably construct your whole defense or your case based on that. So very, very useful. Thank you.
Thank you. I think these are very important points, and I'm sure the audience will keep a note of these, because these are very, very critical when it comes to looking at and leading evidence in arbitration. But Rajendra, when I now come to you, like, you've seen the documents that are required to be maintained, you've heard about the best practices to follow, you've seen the time frames. I think the biggest challenge is always how to retain these records. What are your thoughts? What problems are generally faced in record retention? And if you've had any personal experiences that you will want to share.
So thank you, Raj, for having me here, and kudos to MCI and Khaitan for organizing this webinar on a subject which is extremely unusual, but at the same time very important and very topical. So kudos for that, because at the end of the day, what is a litigation? What is an arbitration without evidence, right? If you don't have evidence, there is no litigation. So it's an extremely important aspect of the whole matter, but something which is a challenge and something where many a times you don't speak about this, but there are important learnings over here. It is, of course, a problem which is faced by many organizations, record retention, and especially large companies, large organizations, multi-locational, with many people, many employees who change over the years. So these problems with regard to record retention are quite frequent in such organizations. For example, absence of relevant people. Now, I mean, from personal experience, if you ask me, I have handled the issues which date back to 30 years, 40 years. And the people who have handled transactions have long gone, either they have superannuated or they have quit or they have been transferred and they are no longer responsible for what they did at that point of time. Absence of personal knowledge is another issue because the people are gone. Absence of records and information, therefore, right? Because the people who have handled the information 40 years ago, where are those records? Where are those files? And I've had experience where, sometimes when those old issues come up, we've had to hunt for files and documents in multiple locations, some of which, of course, Raj knows our travels over a period of time. In my belief, the luckiest lawyer, the luckiest in-house counsel is somebody who probably doesn't have a litigation, right? But then most of us have hard luck. So the second luckiest probably is somebody in whose case a litigation arises closer to the date of the transaction. So within a year, 2 years, consider yourself very lucky. But my experience shows that the luck of in-house counsel is extremely hard. We have very hard luck. Issues arise 10 years later, 20 years later, 30 years later, and where do you go? So it's extremely important to have a system, and glad that Vineet, Smitha, Chakrapani talked about the importance of this issue and what kind of system that could be developed. Problems arise because also today, we are no longer in the old physical file era, right? We are in the modern office era, paperless offices. That itself poses a great challenge because, you look around your offices, you don't find papers and you don't find old papers. right? Offices have become modern, sleek, but paperless. So papers are missing, papers are not available, not easily available, have been destroyed over a period of time. And last but not the least is the challenge of the digital era itself, where today people work on laptops and computers, different laptops and different computers for different people. So unless you have a system in place, your documents and records will be all over. And therefore, when it comes to the crunch, when there is a litigation, you might be having to hunt all over to get the documents and get your evidence together. That is where having a system is something which is extremely important, because then you will be able to track and use the evidence which is relevant at the relevant point of time. And there is something that Vineet talked about is extremely important. We'll have a sort of a central repository. Okay, maybe in the digital era, earlier times we used to have files, right? Create your files, have your contracts, have your correspondence, all of it together. Today in the digital era, see, the way I look at it is the digital era, you can import a lot of practices into the digital era from the past. Create those kind of digital libraries and digital folders where you could have all of your documents together. Use some of the technology, you have a contract management tool available. You have IP management tools available today. So use all of that, create digital libraries, create scanned documents. If older documents, or even today when many of us do contracts which are not digital, scan them and keep those copies together. So that's how I would put it, Raj.
Thank you, Rajendra. I think it was very helpful to know the challenges that actually you face when you need to retain these documents and ensure that the documents are there, so that when it comes to arbitration, we don't falter. But Chakrapani, I just wanted to come back to you on this issue a little bit more. While we've seen the challenges that we face in retaining documents and retention of documents in today's day and age, in spite we are going to digital world, what could be the problems that you would see if the documents were inadequate, or you would say they were not properly maintained? What are the issues that you would face in arbitration, maybe before, during? What are the implications of inadequate or an improperly maintained record or an incomplete record in an arbitration?
So as I'm listening to the views, and before this, Juhi very kindly introduced me saying that 2.5 decades experience. It took me back to one of those early days when I was co-counseling for an arbitration. And I was led by a very eminent senior. And the client was German, a very big corporate facing a copyright challenge here. And we were trying to see how we can help him coupled with a couple of commercial breaches. And in my usual enthusiasm, I have read the papers. I was ready. So I told client, yes, don't worry, we will start drafting and we will be absolutely ready to file things within no time. And my senior had this look on his face. It's like, you may want to take a step back. And it so happened that when we started going deeper into the matter, the entire records were kept in Germany, in Frankfurt. And we were told that, okay, if you want this, and this, is a huge storeroom somewhere off Frankfurt, and you will have to go and find it. So I was on the next plane, again thinking that I'll be able to do it in maybe a day or day and a half's time, and I'll be back and everything else will be fine. It took me 1 week to take out the relevant papers because the records were just dumped, very nicely dumped, I must say, because they were cataloged, they were kept, but everything was there. Now you need to find out what is relevant for that dispute. So that's the first thing that you will face, or anybody would face, if records are incomplete and one is proceeding for an arbitration or a suit. It will delay the matter. That's the first challenge we face, because unless you have your documents in place, unless you have things what you need for foundation of the case, you will be delaying the matter. So that's one thing. That is the challenge that we face when documents are not in order or available. The second thing that happens is that if you come to know that certain document is not there, or it's a court record or some other public record where you can get a certified copy, if you come to know that early, you can ask for it. Otherwise, it may take again forever and set you back for by a while. So delay, what the challenge that we face is delay before filing. When you file it with inadequate records or on the assumption or incomplete record, the case is likely to suffer very badly because the other side will call it out. So that's the challenge when proceedings start. As it progresses, your evidence, if it is an incomplete document, more often than not, and all of us, those who do arbitration will agree, that an arbitral tribunal may refuse to look at a document which is incomplete. So that's another thing that may be a huge setback. Likewise, as I mentioned earlier, if we are confronting a witness with a document and the document is incomplete, it can lead to disastrous consequences, because instead of getting an advantage in confrontation, you may actually end up losing something because incorrect inference may be drawn. So these are the challenges that we will face if documents are incomplete. And that's what happens in some of the cases. And then last point that I want to talk about is that secondary evidence may not be as helpful as the main document itself. So again, that's something that must be borne in mind. Over to you.
Thanks, Chakrapani. I think very important points and very relevant in today's day and age. That brings me to you, Vineet. Today, as you rightly said, we are in a digital era, and all documents, contracts are now being considered signed digitally. They are maintained digitally. So, how does one maintain and preserve smart contracts? Are there any specific tools, methodology that one must keep in mind while dealing with such contracts? You're on mute. You're on mute.
Yeah, sorry. So I think Raj, you rightly put it, and Rajendra, you rightly put an important problem when it goes to organizations, particularly people leaving and KMPs or key personnel leaving, etc. So I think that brings to you what is the kind of system you want to put into place when it comes to e-contracts. And to what comes to my mind is, and that's how we do it, and as I stated, from a contracting perspective, there are enough tools available in the market, the CLMs of the world, right? There are multiple vendors, national, domestic and international, who are providing those tools, platforms, etc. So I think that is one structure that, to my mind, organizations or the legal departments of the organizations must put into place, so that from the opportunity starting to conclusion, in fact, the signing also happens through DocuSigns and Adobes and others of the world now. So it's all electronic, if you ask me. So the entire chain's there. It's all preserved. It's all lying. It's not just available for a litigation, but it's available for even reference purposes. So I think how do you put into place this tool or a structure is something, to my mind, very important. So that's the first piece, I would say. As legal departments, I would say, and in-house, I think it's a pain area, especially when you are being asked to litigate or defend a litigation, and there is no enough papers to kind of to back it up, etc. So I think what also comes into play is this litigation management tool. I think a lot of larger organizations have already installed such tools and systems in place where and in fact they interact with law firms over these platforms now. So there are common folders, there are shared points where the entire data is dumped. whatever is attached is properly indexed or put up there, and therefore it's easily retrievable. So to my mind, those are two things that are important. I mentioned about this e-discovery, and a lot of times we are asked questions about communications, etc., which would have been post award of contract and could be relevant from a litigation standpoint. So I think we don't have those tools, etc., but I've seen some of the law firms use tools, softwares like Relativity and so on, where you kind of extract the relevant what do I say, keywords, etc., from a case perspective. So for example, in a recent matter, we had our managing director and chairman's email being sought in a proceeding to to supplement a claim, or to I'm not getting into all those details. So we pulled out the email boxes, because they're all encrypted and lying there. So we ensure that X11 and above email boxes, because they kind of can lead you to win or lose situations, to my mind, and prove a claim that somebody is bringing in against you. So what we did was, and we what normally do is we put them together. I think then the data segregation happens, because not all data can be given out. I think that's where the law firms also bring that expertise and knowledge. We in-house may not have that competency, so as to say, but I think the tool does the trick. And to my mind, these are some of the tools, technologies which really can come forward, and maybe we as IT platform company can maybe offer these services also. So I'm making a sales pitch as well, but on a lighter note. But what I'm trying to say is, these tools and technologies can do wonders. I know, Rajendra, you rightly mentioned about the risks and the fallouts, especially from a data privacy and data protection and perspectives, like how secure is this electronic data? So that's a different question. I don't think that's the topic, but I think that also is another area. But to my mind, these are some of the places that I can really talk about in terms of how you preserve through tools, technologies, and ensure that you have a good fightable or you have the evidence to support your claim or to negate opposite parties' claims. So I think that's my point here.
Thank you. It's very helpful. Rajendra, that brings me to you. Given the fast-growing digital era, how does one train its employees while dealing with preserving digital and physical records, especially sensitive financial information?
So that's an extremely important aspect. And like I mentioned earlier, it's important to develop a system, to have a process to retain information and records for later use, have it in a systematic manner where it can be retrieved. So a document archival system and a digital document archival system today is the need of the hour. I think one important aspect of this is to maintain all relevant documents, starting from contracts, including correspondence, in one digital file, right? And having it at, let's say, in a cloud location on a drive which can be accessed by the relevant people. That is a system that ought to be there. A sort of a replication of the physical file that we used to maintain in the past. Again, keeping in mind the fact that people change over a period of time, maintaining backups, another extremely important aspect. This is today and going forward. But what about the past? What about 30 years ago? So I think another important aspect is digitizing the old records wherever possible. Old contracts, old deeds, and anything which is relevant, which is either likely to get into a litigation or something contentious, would be important to digitize those old records. And of course, if the data is sensitive, confidential, then in certain cases you could have password protected files. That having been said, having that kind of a system, it's important to train the people also to utilize the system, to use the system, because lawyers by their very nature are a bit, technology and lawyers don't go well together is what time has shown. Unfortunately, if one looks into the future, that is no longer going to be possible. And I think the earlier the community adapts, the better it is. So training the people to use this system and use it effectively and archive in a very systematic and a regular manner is something which is extremely, extremely important. Now you train your current workforce. What about people who join in the future? And so what I think is that as part of the induction program for the function, this is an important training that should be built in, because when you have new joinees, not only do they come in and know the people and know what kind of work you do, but also what kind of systems and processes you have in place, right? For example, like Vineet mentioned, if you have a contract management software, right, a document management system, how to use it effectively and use it consistently is something which is very important, and that training can happen for new joinees at the induction itself. My experience also shows that over a period of time, while, when you implement the system, it is used, beyond certain period of time, a certain complacency may set in, and therefore periodic checks is something which is important to ensure that the system is going. And if there are any hiccups in the system, you kind of look into that and plug those holes. Another important fact is spreading the awareness about the sensitivity. So you mentioned about sensitive financial information. Awareness about the sensitivity. More often than not, legal departments of organizations deal with data, records and information which is very sensitive in nature, which is confidential in nature. So to have that sensitivity as to how to deal with them, keep the information confidential. And you could limit access on a need-to-know basis to people who may be involved in the particular transaction, people who may be involved in that particular litigation. So all of that, I think, is something which can be utilized as training, so that the system which is developed keeps going and keeps delivering in the future.
No, I think this is very helpful, Rajendra. These tips are extremely helpful for any organization to, how to train their in-house people to maintain these records and all. Now, I'm mindful of the time. We don't have much time on our hand, but it's a very important question that I wanted to pick your brains on, Smitha and Chakrapani. And maybe Smitha, you can go first on this. Is sometimes you get some documents which probably have not been obtained legally. Sometimes you have an illegally obtained document that you have in your hand. Sometimes that information is there. Now, how do arbitrators look at illegally obtained documents or information, and are they admissible in evidence?
Okay, I'll go first. So generally, yes, they are admissible. I mean, most arbitration rules or statutes do confer on the arbitrator very broad discretion to decide on both admissibility as well as weight. So even if they are admissible, very little weight may be accorded to it. So there's two issues that would, so both admissibility and weight are what you must consider when you're dealing with illegally obtained evidence. Specifically in relation to evidence that's been obtained illegally, the 2020 IBA rules do address this head on. Article 9.3 provides that a tribunal may, if a party requests or on its own motion, exclude any evidence that's been obtained illegally. And sometimes tribunals do that. But what you see more often is usually tribunals shutting out illegally procured evidence by relying on other grounds rather than the fact that it was procured illegally. So for example, again, the IBA rules 9.2, which most arbitration lawyers are familiar with, it sets out a whole slew of grounds on which a tribunal must exclude the evidence. So these include where their commercial or technical confidentiality, which is compelling, institutional sensitivity. So this would include evidence that's been classified as secret by a government or public international institution. And the next one, which is the most commonly used one, is where the tribunal feels that when you take into account procedural economy, proportionality, fairness, and equality, and it's so compelling that it's been unequal or unfair, they can shut it out. So that usually tends to be the ground that I feel tribunals use when they don't want to make a finding that, oh, this is illegally procured. They'll just say, look, it's unfair. And what usually buttresses this is there's a general duty of good faith in international arbitration, and also codified in certain rules like the UNCITRAL rules. So for example, if the party itself is complicit in procuring the illegal documents, then that would be a breach of good faith. And another factor that would be taken into account in whether to admit or whether to accord weight is whether the evidence is widely and freely available to the public. I mean, this we have seen a lot. I'll give you two very interesting examples. One is CarrotTube in Kazakhstan. It was a case where hacked Kazakh government documents were posted on a website, and that was relied on by CarrotTube in the arbitration. They tried to have it admitted, and the tribunal allowed it on the basis that, look, I mean, yes, they were illegally obtained, but they're already publicly available and were not privileged. So that's one consideration that is usually taken into account. Another example where this idea of it being publicly available already in the public domain is sort of weighing on the arbitrator's mind is where it's the Dominicana Renovables Tribunal. In that case, recordings of conversations were made without the parties knowing. And so they argued, look, there's lack of transparency, there's bad faith. But the tribunal didn't rule on the legality of the recording. Instead, they said, look, the conversation itself was not confidential or private. And so there's no need to exclude it from evidence. So just some examples on this public domain idea.
Chakrapani, do you think it's the same for the domestic scene in India? Any thoughts, quick thoughts on that?
I was going to say that this topic is so interesting that it could take one full day. And those Smitha was mentioning those lovely cases, and it's very intriguing, and those are very interesting as well. Indian perspective, very quickly in a nutshell, is that we don't shut out any evidence, whether it is court or whether it is arbitrator. And for arbitration, it is for obvious reasons, because arbitrator has much lesser powers to gather more evidence and gather more documentation. So it's not shut out, is welcome in that sense, unless it is perpetrating illegality. So if it is illegally obtained or it is available in public domain and obtained by a party, it's fine. But if party itself has been a complicit, then that may not be allowed. Barring that, it's a very broad rule. It's fine. It's admissible. The fruit of the poisonous tree concept does not apply. However, tribunal, as Smitha rightly pointed out, tribunal finds a way to deal with such situations and counters it by some other reasoning. So that's what it is. That's in a nutshell the position in India.
Thank you, Chakrapani and Smitha,
Maybe,
for that.
Raj, if you allow me to add, I think we've created two prejudices in two arbitrations domestic, introducing WhatsApp audios, videos at a much later stage, which were taken on record. We've seen publicly available, I'm not saying illegally procured, but closer to that, etc., taken on record and, creating the difference and bringing the difference. So I think to that extent, arbitration is a great place to be in if you're really, wanting a resolution.
No, absolutely. I think it's very important to have these answers in place. Smitha, there is one audience question which I thought if I can quickly ask you. Actually, there are quite a few, but probably I'll take the first one which has come in, because I don't think we are running out of time. There's others I will definitely respond in writing. The first probably that's coming from Salil Date is document signing or docu-signing or adopt sign can be considered as a valid digitally signed document for arbitrary tribunal court to rely on. Very briefly, your thoughts.
Yes, very brief. Yes.
Okay. So I think we will respond to all the questions that have come in. and we will definitely respond to each one of them. But some of the key takeaways from this session so far has been, of course, there's a lot more to talk about it, but considering the time that we have, some of the key things is that, yes, it's very, very critical that you maintain your documents well. Ensure that when the employees are leaving, their documents are taken into custody. Maybe, if possible, take a witness statement of an employee who's going to leave. Train your in-house employees. Train the in-house employees as much as possible to maintain documents and maintain records. Chakrapani has already told you the kinds of documents that you need to preserve. So I think all in all, it's a very important thing that you have these documents in place, you have sufficient backups, data is available, somebody is even available to thereafter prove a document if it is required to. So you will have to maintain these documents very, very carefully. If we don't maintain records carefully, then we will suffer in the arbitration. The adverse inferences will be drawn on the documents and the evidence that's not properly led. So it's important that we are able to maintain these documents, keep things in place, so that you don't suffer in arbitration. Of course, as Smitha rightly said, maintain the time frame of maintaining this documentation is also equally important. So I think these are the things that we need to keep in mind. I once again thank MCIA for organizing this ADR week. We're very grateful for being participating in this session. And I would thank all the attendees and viewers to join us for this session as well. And all my panelists for agreeing to do this session with me. Juhi, I'll take it. I pass this on to you now. Thank you.
Thank you, Raj.
Thank you.
Thank you. Thank you. I
Thank
think
you.
everyone will agree it was a really fruitful and very engaging session. The only thing to add is that all the sessions of the ADR week, including this one, is being recorded and transcribed. So that will be available on the ADR week's dedicated website. So all the viewers and attendees can also access the recordings and transcriptions there. That's it.
Thank you, everyone.
Thank you so much.
Thank you
so much.
Thank you.